welcome everyone. Bienvenue à la première session de dialogue sur les droits de la personne et le pluralisme juridique. My name is Colleen Sheppard, and I'm going to be facilitating today's session. I've just completed a 5-year term as Center Director from 2010 till this past summer, and I'm delighted to be able to participate in this dialogue series, and this is the first session of 9 conversations or dialogues which are planned to explore some of the work that the Center members have been doing over the past 10 years of our existence. This series, in fact, was conceptualized by Nandini Ramanujam, the Executive and Program Director of our Center, and we thought it would be an interesting way to celebrate and to mark some of the accomplishments of the past 10 years. Just a bit about the origins of the Center. At the time when we proposed this new Center for Human Rights and Legal Pluralism, we noticed that there were many scholars in the Faculty of Law and outside in other faculties in education and the Faculty of Arts who were working on human rights issues, and we thought it would be interesting to try to institutionalize and bring together those scholars into a center structure. We also wanted to weave into the tapestry of our center many of the other human rights initiatives at the faculty, the Human Rights Internship Program, the Human Rights Lectures, various seminars and coursework, and student engagement in human rights. And so when we proposed the center, we identified 3 main objectives. The first was to advance innovative research on human rights and the role of law in a legally plural world. The second was to enrich the nexus of scholarship and teaching by engaging students in human rights research, internships, clerkships, and advanced scholarship. And thirdly, to share our knowledge and to create spaces and fora for the exchange of ideas around human rights through the lens of legal pluralism. Now, why legal pluralism and human rights? And that's the topic that we're going to explore through this dialogue. But at the time that the Center was established, we were committed to a broad and expansive conception of human rights, a conception that included both international as well as domestic or regional and even local human rights initiatives. We were committed to an interdisciplinary conception of human rights. And beyond that, we wanted to build on the trans-systemic traditions of and initiatives of the McGill Faculty of Law. We wanted to connect, in other words, this universal ideal of human rights law to the myriad, complex, multiple, plural legal orders that exist globally. And we also wanted to go beyond just a formal conception of law to begin to interrogate how informal conceptions of law at the heart of legal pluralism are critical to understanding the effective implementation of and respect for human rights. And connected to that was a concern with looking at how human rights impacts on or influences and engages the responsibility of state actors, but how it's also important to think about non-state actors and their role in both perpetuating human rights abuses, but also playing a role in creating the norms that help to redress violations of human rights. So today, I'm delighted to begin our dialogue series, and it is precisely a forum for the exchange of ideas with 2 colleagues who have been at the intellectual heart of the Center for many years. To my left is my colleague, Professor René Provost, who was the first director of the Center from 2005 to 2010. And to my right, Professor Frédéric Mégret, who joined the law faculty as the Canada Research Chair in Human Rights and Legal Pluralism in 2006. Both work predominantly in the domain of international human rights and humanitarian law, and both integrate the insights of legal pluralism into their scholarship. So I've prepared a series of fairly informal questions to begin this conversation, and I also want to say at the outset that I'm going to speak probably predominantly in English because I'm most comfortable, particularly in a setting where it's not all scripted. Mais on a une politique de bilinguisme. Et mes collègues vont peut-être parfois répondre en français et on va continuer un peu le dialogue en français ou en anglais. C'est juste pour vous dire que probablement moi je vais parler un peu plus en anglais parce que je suis plus à l'aise, mais évidemment mes collègues vont choisir la langue de leur choix. Mais aussi, I wanted to say that we're going to begin with, I'll begin perhaps just with the questions. So, to start off, instead of giving you a longer biography of the past work and diplomas and prizes, etc., scholarship of my colleagues, I thought we'd focus in on their, and I'd ask them to tell you a little bit about themselves, and focusing on why and how they became interested and engaged in human rights issues and research. So perhaps I'll begin with René.
Okay, thank you, Colleen, and it's nice to see familiar faces, friends in the crowd. L'idée qu'on a eue au départ, c'est de parler un peu de nous, non pas nécessairement par nombrilisme, mais plutôt sur la base de l'idée que, à l'instar de la pensée du pluralisme juridique, l'individu est lui-même ou elle-même un site d'internormativité. Donc, on est nous-mêmes des sites où se rencontrent les droits de la personne et le pluralisme juridique. Et c'est donc pertinent du point de vue d'une réflexion initiale sur les liens entre le pluralisme juridique et les droits de la personne, de parler un peu de notre parcours qui nous a menés à réconcilier ces deux thématiques-là. De mon côté, j'ai eu un parcours un petit peu indirect, disons, vers les droits de la personne. Je peux dire que j'avais vraiment aucun intérêt pour les droits de la personne au cours de mes études en droit. J'ai pris un seul cours de droit international, malgré avoir fait toute ma carrière en droit international. Le seul cours que j'ai suivi comme étudiant, c'était un cours obligatoire en première année, qui m'a un petit peu enlevé l'envie de prendre d'autres cours pour les années qui ont suivi. Et c'est seulement quand j'ai passé une année comme clerc à la Cour suprême du Canada, j'étais clerc pour le juge Claire Leroux-Dubé, où c'était les premières années de l'application de la Charte canadienne des droits et libertés. Il y avait très, très peu de droits canadiens existants, ou peu au niveau de la Cour suprême. Il y avait environ une demi-douzaine d'arrêts de la Cour à cette époque héroïque. Et donc, beaucoup des questions étaient en droit pénal, beaucoup autour de l'application des droits fondamentaux. Et donc, ça a été un peu mon parcours, mon entrée dans le monde du droit de la personne, ça a été par l'entremise de l'application de la Charte canadienne des droits et libertés, surtout dans le domaine du droit pénal à la Cour suprême du Canada. Un intérêt que j'ai poursuivi par la suite quand j'ai été faire des études supérieures à l'Université de Californie à Berkeley, où là, j'ai un peu continué cet intérêt pour la protection constitutionnelle des droits fondamentaux, mais d'une manière comparée en m'intéressant au développement d'un concept latino-américain, le droit de l'amparo, qui est une espèce d'injonction, mandamus, une espèce de super remède disponible en Amérique latine, et une étude de la pertinence de ce remède-là pour le droit constitutionnel canadien. Donc, une étude comparative. Par la suite, j'ai habité à New York et travaillé pour Human Rights Watch. Et c'est là où, pour la première fois, on m'a demandé d'œuvrer dans le domaine du droit international en rédigeant un rapport sur l'interdiction, l'embargo couvrant la nourriture et les médicaments imposés par les Nations unies contre l'Irak et le Koweït suite à l'invasion du Koweït par l'Irak, et l'argument que cet embargo onusien violait le droit international humanitaire. Et je ne connaissais absolument rien au droit de la guerre. Ça a été un petit peu mon apprentissage autodidacte de ce domaine du droit international. Et par la suite, quand est venu le temps de préparer une demande pour faire mon doctorat, j'ai eu une conversation avec le professeur Lou Henkin à Columbia University qui m'a dit qu'est-ce que vous avez fait? Alors, j'ai fait Amparo, droit de la personne, et puis droit de la guerre. Et donc, c'est lui qui m'a suggéré un peu la piste de l'interaction du droit international des droits de la personne et du droit international humanitaire sur lequel j'ai écrit ma thèse de doctorat. Le dernier aspect que je mentionnerai du parcours, c'est en fait mon arrivée à McGill et mon apprentissage ici en tant que professeur. Ça a été vraiment une deuxième éducation juridique. Je suis pas parti de zéro parce que j'avais quand même plusieurs années de formation en droit, mais ça a été un nouveau départ sur des bases considérablement différentes, entre autres par le travail pour l'élaboration du nouveau programme transsystémique et l'intégration du droit civil et de la common law, qui a fait un peu exploser certaines préconceptions que j'avais quant à la cohérence interne nécessaire de chaque tradition juridique et que la combinaison peut mener à un enrichissement plutôt qu'à une confusion totale, ce qui bien sûr est une pensée qui est très proche du pluralisme juridique. Et par la suite, j'ai enseigné un cours en première année ici, le cours de fondement du droit, qui, là encore, a complété mon éducation, m'a poussé dans de nouvelles directions théoriques que j'avais complètement ignorées lors de la rédaction de ma thèse de doctorat et qui, je le réalise aujourd'hui, aurait considérablement enrichi mon approche dans ma thèse de doctorat. Mais bon, les thèses de doctorat sont toujours des choses auxquelles qu'on considère avec un peu de gêne par la suite, mais néanmoins, c'est ça qui m'a mené ici à travailler dans le domaine du droit international des droits de la personne.
Okay, merci beaucoup. And I think it's really interesting, the idea of an intellectual journey. And so I want to turn to Frédéric.
Yeah, and I found René's description of his trajectory fascinating, and I am always struck by the degree to which we are the product of encounters with the law, educational encounters, internships, and there's always something a little accidental about any intellectual trajectory, and probably one of the challenges is to let these experiences grow on oneself and not resist them with some preconceived paradigm of how the law is supposed to fit in certain preordained boxes. So I suppose my own trajectory is broadly similar. I was quite interested in international law from a start because I saw it as a sort of ticket out of both my home country and also sort of a private law niche that I was initially educated in. And human rights seemed like a good cause, I suppose. Intellectually, I was sort of fascinated by, and I think I've always been fascinated by the sort of question of how and whether legal systems ever change and who decides and why. And so it always seemed as if human rights, as a branch of public international law, but also as a something that wants to overwhelm public international law and become international law in lieu of public international law, was in a relationship of tension and my doctoral work was on international criminal tribunals, which are one of the many ways in which international criminal justice, one of the ways in which one can think about the promotion of human rights today. And then I also have to say that coming to McGill was had a huge impact, and I arrived long after the trans-systemic project had been launched, but the realization that there was considerable space here to reimagine what international human rights law might mean beyond, the case law of the European Court of Human Rights, or detailed classes on exhaustion of local remedies was, certainly an invitation to move beyond. And that's even before I'd, really dabbled in legal pluralism. So.
And just to elaborate a little bit in terms of where you did your studies and how you ended up in Montreal and McGill. Can you just tell?
I wonder myself, Colleen, sometimes. but so, you made this point, about bilingualism of this faculty. Et c'est clairement quelque chose qui m'a attiré de loin, d'Europe. Et je pense que on n'est souvent pas là où on finit entièrement par hasard, et que les langues sont des véhicules d'approche culturelle mais aussi intellectuelle, et que la combinaison des langues est quelque chose d'extrêmement riche. So I don't actually write the same articles when I'm, writing in English when I'm writing in French. They're like the two, I have my French persona and my English persona. And I think that's, because different audiences, different styles, different traditions. And I think, in terms, but of course, all sort of, broadly talking about, well, I try not to contradict myself, right? But the two are really different. And I think, there's I think a metaphor there about how sort of within, let's say, international law, international human rights law, maybe a sort of single subject can be engaged in very different cultural or functionally determined activities. So, and it's not a total coincidence, I think, that legal pluralism and trans-systemic project emerged in a bilingual city and a bilingual faculty. So all these things are connected by language, I think, and by the logos, our use of words.
And I know, just to probe a little bit further, but how did you get from René was talking about how he began with a certain understanding of law and how that became increasingly more complex, and how some of the theoretical dimensions of legal pluralism, which I'm going to turn to in a moment, informed his work regarding human rights law. But I'm wondering how, because much of your work is highly theoretical and interdisciplinary and philosophical even, but how did you go from sort of legal studies in France to developing that bent?
That's a good question. I mean, I think I was just painfully aware of the limitations of the legal education I received both in the UK and France. And intellectually not particularly drawn to it. I mean, I think, the first reason I was probably quite bored, and so I was looking for something else. But, boredom is an interesting resource for creativity. But I think more than that, it always seemed as if what we were taught in law school was, maybe not an elaborate lie, but occasionally bore little connection to reality. Certainly, the sort of a dominant formalist, the sort of doctrinal approach to the law, interesting as it is, and revealing of a particular intellectual tradition as it is, didn't really seem to make sense of our intuitions about the role of law in society or how one might effect change. And in addition, didn't really provide us with much of a critical discourse to tackle the law itself. So, I see the move to theory as in itself generally quite critical in law. And actually, to be a theorist still today in many continental European faculties is to, do something that is really not law. So you're easily ostracized and disqualified. Maybe it's not as bad now as it was 20 years ago. And I also saw theory as a vehicle for a more global conversation that allows one to extract oneself from a particular tradition. The other thing is, I studied both the common law and the civil law, not as part of a trans-systemic program, but as sort of first my LB, then my maîtrise in Paris. And people who've only been trained in one tradition tend to see the huge differences between them, and will tell you, well, I could never think like a common lawyer, etc. This is so weird. But when you've actually studied both at the same time or in short sequence, you kind of tend to see a lot of the commonalities as well. Enough commonalities that you're likely to think that dialogue is very possible. And maybe one point on this, because I think it is linked to legal pluralism and international law. One of my first, I think this was actually the paper I presented for my job talk at McGill, was on the fusion of common law and civil law traditions in international criminal law, both procedurally and substantively. And in effect, I mean, international law, although that is, I think, a slightly forgotten part of history, has always drawn heavily from domestic legal ideas and domestic traditions. I mean, and is a kind of constantly evolving synthesis of these various traditions of thought. So to do international law is to do kind of transsystémisme avant la lettre, I think. Yeah.
Thank you. Okay, I want to move to a very basic question, but one which many of us get asked often, and one which I think is important as a starting point for thinking more deeply about the connection between human rights and legal pluralism. And that is, how do you understand or conceptualize the concept of legal pluralism? So I don't know who would like to begin.
It's a tough one. René, do you want to?
Well, so legal pluralism, as I understand it, and it really, the very concept denies the possibility of a monopoly on the meaning of legal pluralism. So legal pluralism has to be pluralistic about its own definition. But that caveat being shared, let me have a go at it. So the suggestion that legal orders are multiple is to some extent unremarkable. Everybody knows that. You don't need to be a legal pluralist to appreciate that. But the first question raised by legal pluralism is the extent to which that can be enlarged to incorporate normative orders that are further and further away from the states and organized structures to more informal norms of social organizations. And so in that respect, there are boundaries, the outer reaches of which legal pluralists tend to inhabit or explore, to ask, what does it bring us? What does it help to ask the law question about this kind of ordering that doesn't look like law prima facie, but that perhaps might be conceived of as law using the toolkit of legal pluralism. So for example, I recently completed one article where I explore various implications of cannibalism for law. So a bit of an esoteric subject matter, a very anthropological subject matter, but not a very legal one. And one of the questions that I ask is it possible to consider cannibalism as a legal form? And in other words, is it possible to consider the practice of cannibalism as a social practice that can be codified within a particular community in ways that we would identify as law? And that is meant to be a provocative suggestion, but also a device to test how far can we take this concept away from kind of a positivist understanding of law.
Just to interject there, you were looking at historical examples of cannibalism?
Sure. I mean, not necessarily ancient history, but in fact, mostly relying on anthropological, ethnographic work during the 20th century, mostly amongst remote tribes. And so what I found is that there are certain forms of cannibalism that indeed are heavily regulated. Who gets eaten, what part, how's it prepared, at what occasion, what order, what do you get out of it, why do you engage in such practices? All these are questions that in some communities are answered very, very specifically, and in some sense it is a custom like any other. And it is, in effect, the hesitation to label it as a legal form originates elsewhere than in what defines law as such. And I also explore issues related to morality and the connection between law and morality, and whether that would pose an obstacle in a Western conception of law to labeling cannibalistic practices as a form of law. And analyzing someone like Lon Fuller, who has explored perhaps more deeply than anyone else that question, I come to the conclusion that no, despite what we might intuitively think, nothing in the connection between law and morality that is posited in some of the legal theorists' work would lead to reject necessarily those kinds of practices as law. So legal pluralism leads you to ask different kinds of questions. And I'm hard-pressed to think how I could possibly have come to ask myself this question if it were not for legal pluralism and the challenge that it puts to every jurist to explore the outer boundaries of our concept of legal normativity.
Okay, and maybe to add to that, we'll come back to how human rights, international human rights law, universal norms intersect with this recognition of multiplicity, the multiplicity of legal normative orders.
Sure.
But maybe
well,
just to add,
just to add to what René just said, which is very useful. I think you can think of legal pluralist claims as operating as different kinds of claims. So there's a sociological claim, about the coexistence of, or an anthropological claim about the coexistence of normative orders, which isn't particularly preoccupied with the sort of canonical questions that lawyers ask themselves. There's a legal theory question, which is very much the sort of questions that lawyers at least ought to ask themselves, which is, what is law? Are these subsystems of law as much law as the law that we've been used to describe as law, which for many of us is law as promulgated by the state? And then there's a normative question, which is, is it a good thing? To pick up on your yikes comment, how far do we want legal pluralism, even though it clearly exists and as a kind of heuristic paradigm, it's useful to go, and that brings us to the question of human rights that we'll address shortly. So I don't want to anticipate on that, but I did want to point out that legal pluralism, before rather than something that actually exists out there, it is very much an intellectual paradigm, right? So it has its own historiography as an intellectual paradigm, and it has its roots in the colonial encounter. And I think that's something that's really important, that legal pluralism, is at least a rationalization of a number of practices which your average colonial officer wouldn't have thought as, fitting under that heading, but which basically involved the negotiation of a frontier between metropolitan law, the law of a colonizer, and then tolerance for local norms, and the realization that, even after 50 or 100 years of colonization, these normative systems were extremely resilient, and in fact that it was probably in the colonizer's interest to defer to them to an extent. And now all kinds of weird things happened as a result of a colonizer trying to absorb these customs into its own laws with various systems of oversight and codification, etc., which shows that it's actually difficult to have legal pluralism in a monist system dominated by the state, because the state kind of spoils the diversity in a sense, not entirely, but it has a tendency to. So that's, I think, the origin. It's an important origin. What happens in the 70s onwards, people, particularly in Canada, start taking up these ideas and saying, well, couldn't we use legal pluralism to understand the normative and legal reality of post-industrial societies where, you know, trade unions and churches and your local club are all normative orders, right? And, you know, the extreme sort of, you know, consequence of this regretted colleague Rod MacDonald and the idea of everyday law, that even a hockey game in the street in Montreal amongst kids is generating legal norms over time. So I wrote one piece which is a sort of my most legal pluralist piece with no element of human rights. And in another life, many years ago, I was an avid tango dancer. I used to go to Buenos Aires a lot. And as part of a symposium organized in Quebec on interdisciplinary studies of tango, I wrote a legal pluralist analysis of the Buenos Aires, the Porteño Milonga. The Milonga is the place where you go and dance tango dance floor. And it was all about the codes, highly peculiar, you know, and really almost seen as quasi-laws of the dance floor. So what are the do's and don'ts? How is it enforced? You know, what happens if you step on, you know, someone's feet? You know, who are you allowed to invite? Who can you not invite? When is a no, etc. And so it's a rich. I think it's very rich. And if we let go of, you know, the ontological question, well, is this really law or not? To say it's an interesting normative microcosm that probably, whether it's law or not in the canonical sense, tells us something about how normative systems function, then, you know, there's just no end to the sort of results that can yield. Yeah.
Yes, and this, I mean, it shows the complexity of those systems. And Fred's article on the codes of Milonga is, you know, one reason when I lived in Buenos Aires I never wanted to learn the tango is because I was aware of how incredibly complex to negotiate it was to actually venture on the dance floor. But what it also speaks to is another dimension of legal pluralism. So there's the multiplicity of legal orders, but there is also the idea of the interaction. And we have that incipient in Sally Falk-Moore's landmark article on law as a semi-autonomous social field, in which she explores some legal practices and says, well, they operate in sort of the shadow of the formal law. And looking at the textile industry in New York or the Chaga tribe in Kenya, she says, well, formal law does seep in, it influences, but it never completely occupies an area, just like the Milonga Code is also penetrated by formal law. What it doesn't actually speak about is that space of interaction. And I think that this is a particularly rich insight of legal pluralism, not merely the multiplicity, but the encounter, or you could frame it as the space in between various legal orders as a prime site of investigation for jurists. And the way in which we talk about these other legal orders is as other legal orders. And if I can go back to the colonial experience that Frédéric was mentioning earlier, one of the particularly fascinating things about it was not merely the fact that when colonial administrators were writing down the indigenous customs as they perceived it, which already was doing violence to a reality as it was experienced by the people by the colonized. At the same time, they were also inventing their own version of English law, for example, for an English colonial officer. So they projected or they constructed kind of an idealized version of what English law was about to have a point of correspondence or contact with indigenous law. But of course, the reality is that the English law that they created was nearly as unreal as the indigenous law that they were codifying. So what that suggests is that the the simultaneous presence or existence of legal orders leads them to define themselves in relation to the others constantly, so that we define our notion of what law is by constantly rejecting other legal orders as not legal, or enlarging our conception of law as perhaps including cannibalistic practices, as I suggested earlier.
One more small thing, which is reminds me. So, I mean, the exception to that is legal systems in the modern Western sense that officially, formally recognize the plurality within them. And of course, Canada is this is kind of almost a third meaning of legal pluralism, is the coexistence of legal traditions within a broadly unitary, even if it's federal, legal system. And there, of course, Canada is a very rich terrain to explore, not just the coexistence of a common law and a civil law, but also indigenous legal traditions, and has forged over the years, academics in Canada links with people working in other dual system or dual tradition, whether it's Louisiana or Scotland, in very interesting ways. Yeah.
And I think just that idea of the Canadian experience in indigenous legal orders prompts us already to begin making the connection with human rights, because the recognition or the non-recognition of a legal order can implicate a significant violation of the collective rights of a community. So did you want to add something in there?
Well, I was just going to add that, so in this other version, in Canada, we see, for example, the role of the Supreme Court as attempting to harmonize civil law and common law approaches to particular issues as interesting, because it's not an idea of unification, it's not an idea of erasing the difference or merging two traditions to make them one, but rather to articulate the nature of the relationship of two traditions and two normative orders that remain distinct but are nevertheless constantly interacting one with the other. I mean, we have a similar dynamic in the European Union with some parts of the law of the EU being attempted to be unified, but other parts to be harmonized as opposed to unified.
And I think that very much gets us to international human rights law.
Right. I thought this was going to be difficult, but it's very easy with my colleagues here. So we've talked a bit about conceptions of legal pluralism, but now I want to ask you both to just share with us how then legal pluralism as a concept is integral to your work in the domain of human rights, or how the two intersect through. I mean, René has already talked a bit about the cannibalism example, and you've talked about tango, but perhaps in other more human rightsy type right. context.
Sure. Well, maybe I can start with this. I mean, I think the project of international human rights law is very much embedded into public international law, and in some ways, weirdly, you could say questions of pluralism have always been central to the constitution of the international system. I mean, the Westphalian system is a legally pluralistic system in a sense, but of a very peculiar kind, right? Because there's no sovereign. The Universal Declaration of Human Rights and the contemporary projects of human rights of a global level is one that seeks to, I think, in large part, transcend the sort of traditional, incommensurable pluralism of the Westphalian system by saying, well, there is this thin layer of things that we could all agree to as an international society. Having said that, the minute the ink is dry on the Universal Declaration, actually a year or two before, the South Americans had adopted the Inter-American Declaration, and then the Europeans 2 or 3 years later adopt the European Convention. And what they seem to be signaling, apart from the fact that it's easier to adopt a treaty at the regional level, is that they're going to forge ahead with their own understanding of human rights, thank thank you, and that will, maybe not include economic and social rights, or maybe emphasize, that, as in the case of the Inter-American Convention, that, the right to life is from a moment of conception, so that, there's already a sort of anti-abortion stance built into the treaty. So I think what's interesting is very quickly we realize that if we're going to have universal human rights, either it's just going to be an illusion, or it's going to be so thin as to not be a very mobilizing project. And this kind of cosmopolitan ideal needs to be translated. It needs to be now. That's not very radical legal pluralism. It's regionalization, etc. Then when you move to the regional scale, the European Court of Human Rights is dealing with 1 billion people, 50 countries, all kinds of histories and traditions, etc. So quite quickly it realizes that on issues that are a bit at the cutting edge of mores and evolving ideas about society, family, etc., it can't really take a lead, and it invents a tool which is the margin of appreciation, which is the idea that on a lot of these sensitive, more cultural issues, states can remain within the sort of under the human rights umbrella, but elect quite different policies. So there's this realization, that international human rights law can't be like this, domestic law, that it's always going to have to allow for considerable variation. So I think that's one of the things I've been interested in terms of thinking about the tension between universalism and localism against a background where there's always been skepticism about the truth claims implicit in human rights and suspicions about human rights historical and geographical origins. The other thing I'll maybe mention briefly is I think one extraordinary thing that has happened one has to remember that human rights were invented in the 18th century as very much a sort of an ideology of emancipation of the white middle class, and remain compatible for most of their history with fundamental forms of exclusion, including racial discrimination, etc. And even the U.S. seemed to think nothing of the fact that they were voting and sponsoring the Universal Declaration, but at a time when segregation was still very much a reality in many U.S. states. So I think what's happened is an interesting, problematic, and complex process of reclaiming of human rights by various groups that historically have been excluded from them. And Rorty once said in his Oxford Amnesty lectures that the history of human rights is the history of defining who is human. So forget about the discrete catalogues of rights. It's a contestation over the meaning of humanity, which may seem very obvious to us, but obviously, historically, a lot of groups or have been seen as less human than others. And so I've been looking at how international human rights law has gone through that own metamorphosis from an idealized kind of human being, which is sort of interchangeable, to including more and more sort of groups that are seen as having irreducible needs or as requiring at least a slightly different approach than the one-size-fits-all approach typically promoted by human rights. And I think that's part of pluralism as well. I mean, obviously a lot of the feminist critique of human rights and the international human rights movement, it's heavily focused on the public sphere at the expense of forms of violence experienced by women, which affect their rights experience possibly more than traditional forms of state repression. I've worked a lot on the rights of persons with disabilities, a little on the rights of older persons, which is an emerging issue today. There's a big push internationally on LGBT rights, which is, again, sort of really pushing the boundaries of human rights. So legal pluralism, I think, can be thought also in this way, not just in terms of a diversification of a sujet de référence of human rights, but also in terms, I mean, what's very noticeable is all of these changes were brought from the bottom up, right? I mean, it's not as if the High Commissioner for Human Rights sort of woke up one day and say, oh, well, we haven't been doing anything for people with disabilities for the last decades. There's people with disabilities who basically had to mount a sustained attack of a sort of dominant paradigm, and who would otherwise have been consigned to disability rights, which was very much a sort of, as opposed to the human rights of persons with disability, which is slightly different. So this effort to be taken seriously and to find one's place in a paradigm is fascinating. What's interesting is it doesn't leave a paradigm unscathed, right? So that the paradigm itself has to change and ask questions about what it stands for. Yeah.
And I'm going to come back to that in terms of the bottom-up idea and how social movements and others use and resist law and legal conceptions and human rights norms. But I want to just ask you for a couple examples of how your work in human rights has evolved or changed, or how it currently incorporates some of the insights of legal pluralism.
Well, let me start by not answering that, and maybe saying I agree to a large extent with what Frédéric has been saying, but I would situate within the concept of human rights itself a certain tension that only legal pluralism renders visible. So let me explain that. So human rights is an old idea, but an idea that is full of contradiction. And for me, the starkest example, even more so than the ones you've given, is the U.S. Constitution that proclaims these fundamental rights that we hold dear, but at the same time allows for slavery to go on for decades more until the Civil War. And so you have one of the founding documents of human rights in law on the one hand, and on the other hand, the legal validation of one of the most fundamental denials of human rights in slavery. And when human rights law emerges into positive international law on the ashes of the Holocaust and the horrors of the Second World War, there is very much a desire to never again, as the saying went, not never again allow for a genocide to occur, but never again fail to answer the call of those victimized. And so the promise of human rights is the promise to each individual to, as human, to be respected in ways that are described in the Universal Declaration of Human Rights. The problem is that the human being that is defined in the Universal Declaration is quite amorphous. And that is good in the sense that every one of us can find himself or herself in that human being projected by the Universal Declaration and other instruments. But likewise, others can exclude us by their own exercise of interpretation of the qualities of the human being in human rights documents. So human rights law includes and excludes in equal measure. And that is something that really fails to be reflected in the standard narrative about human rights law that up until legal pluralism dominated the discussion. So what Rorty was talking about in his Oxford lecture was the fact that in the former Yugoslavia, when one group was persecuting, torturing the other, they weren't doing that to a human being. So what was the problem? On the contrary, they were defending the sense of humanity that they shared with their own community, but within which that victim did not fit. And so the claim isn't about arriving at a better definition of what a human being is or at some level of objectivity, but rather to mediate our differences as to what we believe makes us human. And this is what human rights law is for. It's not about giving answers or solutions to what is equality, and a good interpretation of the law will give us the clear answer. And once we discovered that, we'll be done with the equality thing, and we can move on to the other rights. It isn't any kind of promise like that, but rather it gives us a tool whereby we can have an exchange that is rooted in respect for human dignity, but that acknowledges that these are indeed differences, but that there are ways in which we can decide that they are inconsequential. And these are the terms of the dialogue that human rights law allows, such that diversity and plurality are inherent within the very concept of human rights in ways that really do not, they do not appear in a classical reading of human rights law.
I just ask you to clarify, because I'm not sure if I totally understand, because there does seem, human rights, these universal norms, does seem to project a kind of normative values that trump in some instance, or that it's not a world of total cultural relativism, right. That we may be able to say that there are some things which we find abhorrent, yeah. And that we develop a more global consensus around that. So it's not right. That all law, regardless, is equal, but the project of universal human rights law was to work towards common recognition that there were some wrongs embedded in what we consider to be these universal human rights, which are important. Not to say that that doesn't mean that we should take into account how these universal norms operate in complex and plural legal orders which contest and intersect with them, and where there are exceptions. But I wonder if, I don't want to misunderstand, I'm not sure I understood, but it seemed that I'm not sure whether your perspective is one that's more culturally relative than the one I might.
I suspect probably. And I mean, one thing you didn't mention in your introductory comment about the creation of the center was that initially it wasn't called the Center for Human Rights and Legal Pluralism, but rather the initial idea was to call it the Center for Human Rights and Social Diversity. And for various reasons, we got reoriented towards legal pluralism. But what it speaks to, and I think it connects to your comment, is what's the relationship between human rights and social diversity, and is that relationship a clash or a conversation, you could say. And in the way that you present human rights, I would say, well, this is a certain essentialization of human rights law and of the picture of what a human being is as embodied in human rights law. And my sense is that we will never be able to win that argument. And it then becomes a debate about the essential characteristic of a human being. Whereas if you try to, if you accept the diversity of the concept even within human rights law itself, then these are two plural concepts interacting one with the other and arriving at something that can be the terms of living together, which I believe is what human rights offers.
Want to jump in
to that? Yeah, I think one of the things legal pluralism makes us aware of, it's not the only paradigm that does so, but is the the violence that is inherent in the law, and particularly sort of positivist forms of adjudication. And if you look at the case law of even the most well-intentioned international human rights courts, they occasionally get it extraordinarily wrong, and you might think it's down to prejudices, etc., of the judges or whatever. But there's also something to this idea that combining human rights and sort of centralized, sovereign-backed adjudication is something that can be very problematic. And in that respect, one of the projects that was launched at the center, which is still ongoing, is the Article Lab, which is an attempt to work collectively on articles, has been looking at alternative human rights-based alternative dispute resolution as opposed to adjudication. So what might it mean to think of human rights outcomes not being decided by, even a grand chamber of judges, but human rights to provide a framework within which disputes are settled through negotiation, through a greater awareness of the other side's point of view, something which clearly adversarial, confrontation doesn't particularly encourage. So I think there's something here about the modes of production of human rights and the idea, of course, we're still used, and I think romantically attached to this notion that rights are rights, they are things, they exist, and they're surely worth preserving. But the consensus on, it's such a thin conquest, the Universal Declaration, because the minute you inquire as to the meaning of even such a central right as torture, people will disagree. There's, of course, a core, but there's a huge penumbra. And so to think of, our attachment to the prohibition of torture is in a sense an empty attachment because there's still a lot of work that needs to be done. And I think legal pluralism maybe doesn't provide all the answers, but certainly shows us the extent of a task because, is solitary confinement torture? Is female genital mutilation torture? Is hunger, chronic hunger that could be prevented easily by government? Is that a form of torture? Is sending someone back to a country where we wouldn't have the same standard of healthcare a form of torture? So I think as we become aware of a sort of dizzying range of alternative answers to these questions, I think we reinvigorate the sense of human rights as a sort of ongoing struggle that the law has never really, relieved us from carrying.
Just to probe a little bit on that, where does power then come into it? I mean, you talked about social movements claiming their inclusion, disability rights, women's movements, and you talked about negotiation and mediation as alternatives to appealing to the apex of the judiciary as to decide and adjudicate claims. But how does power come into play in this framework? And because I worry about groups without power being left out of the conversation or the dialogue or the negotiation.
Right. Well, a lot of the strategies of kind of circling around human rights and trying to, secure a foothold within the human rights edifice are strategies of power, in a sense, right? I mean, there's an intuitive understanding that to be part of the law or to be taken into account by the law is a form of power. It's something worth achieving. My sense is often that, il y a un peu de l'ardeur du néophyte in those efforts to sort of conquer the law, and sometimes from outside the law, a little too much hope in the law's emancipatory potential. So my word of caution, when sort of, someone wants to write a paper with me with, so a new treaty on a new right or sort of to protect a new group, is I recognize that as a classic liberal strategy that is interesting for what it's worth, but it's also, don't put all your eggs in the same basket. And remember that the power that you conquer is also the power that ends up oppressing you, and that it's important to keep a foot outside of the law, particularly with an idea such as human rights. So, I think the idea that human rights would be brought about and diffused at a universal level through a kind of broad supranational technocratic apparatus must rank amongst the least convincing, sort of ever produced. If you look at it, most human rights advances, and I'm talking about the Bastille, but also decolonization struggles, the indigenous rights movements, etc., were conquered not only before the courts, but also as a result of speaking truth or justice to the law, and not being naive about its potential. So yeah.
And that also goes to the idea that most of our international human rights instruments are framed in terms of imposing obligations on state actors exclusively. When we see the limitations of that framework And indeed, when in the indigenous context, for example, that could be deeply problematic.
Oui, c'est un reproche qu'on peut faire à une critique pluraliste juridique des droits de la personne, c'est que on introduit un flou qui vient un peu nier le caractère efficace de ces normes-là. Et dans les faits, on ne cherche pas nécessairement à désarmer la victime qui a besoin de protection aujourd'hui parce qu'elle est persécutée pour son orientation sexuelle ou quelque chose comme ça. Et donc, il faut utiliser cette critique-là avec soin, mais il faut aussi se souvenir de ce que des gens comme Mari Matsuda ont souligné, c'est-à-dire que, bon, à certains moments, il faut être en dehors du palais de justice à protester contre le système, mais à d'autres moments, il faut être dans la cour, au tribunal, à plaider pour ses droits, et qu'il n'y a pas nécessairement de contradiction entre ces deux positions-là. Pour moi, c'est un peu ça, le pluralisme juridique, c'est qu'il faut aussi s'intéresser à des limites systémiques du droit international des droits de la personne qui vont affecter tout ce droit dans son ensemble parce qu'elles sont réelles, ces limites, mais néanmoins pas renoncer à la possibilité d'application concrète dans des cas donnés. Et un des exemples, je pense, où ça ressort particulièrement bien, ce sont les situations où l'État n'est pas présent. Donc, on peut penser à des situations où l'État a disparu. Par exemple, on peut penser à la Somalie, il n'y a pas de gouvernement depuis des années maintenant, ou encore des situations de conflits armés, particulièrement de conflits armés internes. Comment s'assurer que des groupes insurgés respectent les principes des droits fondamentaux? Ce sont des groupes, comme tu disais tout à l'heure, qui, eux, détiennent un pouvoir, sont dans une position qui va les mener à opprimer, nier des droits fondamentaux. Comment est-ce que nous, comme juristes, on va rejoindre ces groupes-là? Est-ce que le droit, comme disent les théoriciens des relations internationales, est-ce que le droit peut avoir un compliance pull dans ce contexte-là? Il est clair que les réponses que nous donne un petit peu une approche plus classique au positivisme, axée sur l'État et la création d'institutions, ne va pas nous mener bien loin dans un contexte comme cela. Si on pense au conflit en ce moment contre l'État islamique, si on les trouve, on va essayer de les bombarder. Donc, ce n'est pas clair qu'on peut les rejoindre pour les obliger d'une autre manière. Donc, il faut trouver des façons d'aller rejoindre ces groupes-là parce que, pour moi, je pense que comme juriste, c'est simplement inacceptable de se dire « Ah, mais on ne peut rien faire ». Et la seule solution, c'est de gagner la guerre. On peut s'entendre que c'est sans doute la meilleure solution et que c'est nécessaire aussi, mais en attendant, on ne peut pas simplement larguer ceux qui sont soumis au pouvoir de groupes comme l'État islamique. Il faut quand même essayer d'agir pour les protéger et ne pas accepter que c'est simplement une limite à l'effet du droit international des droits de la personne. So legal pluralism, as I was saying earlier, gives us a toolkit to engage in a conversation even with people that have a fundamentally different conception of what fundamental rights are, of what a human being is, and also possibly a different Grundnorm as to what law is. And all these terms are open to negotiation, and there is no way to bypass the negotiation to simply decide that this is the vision of what law is, and these are human rights, and that's what you must do. I mean, we can try it, and we do, but it is largely pointless to merely just repeat it as some kind of incantation and do nothing to actually engage with such groups.
Et l'exemple que vous venez d'expliquer, que tu viens d'expliquer, touche votre nouveau projet avec la Fondation Trudeau, qui va être intéressant.
Yeah, sure. And ouais, et bon, dans ce projet-là que je débute, donc je m'intéresse en particulier au phénomène par lequel des groupes insurgés vont créer leurs propres tribunaux. Et donc, ça peut paraître un peu absurde de penser, OK, l'État islamique a créé ses tribunaux et ils vont citer la Déclaration universelle ou le pacte sur les droits civils et politiques, sur le droit à l'avocat. Et puis bon, c'est clair que la caricature est facile. Cela étant dit, dans les faits, ces groupes-là, non seulement l'État islamique, mais bon, le Free Syrian Army, et puis tous les groupes dans tous les conflits armés internes, les insurgés ont toujours des prisonniers et vont très souvent les juger pour des crimes qu'ils ont commis. Et nous, comme juristes, on doit s'intéresser à ça pour tenter de rapprocher ces processus-là de l'équité procédurale autant que faire se peut. Donc, c'est évident là qu'on ne va pas parachuter des spécialistes de Human Rights Watch qui vont être accueillis à bras ouverts par l'État islamique pour qu'ils se fassent expliquer comment ça fonctionne pour de vrai. Mais d'un autre côté, ce n'est pas vrai non plus qu'on ne peut rien faire. Pour moi, ça, c'est simplement inacceptable.
Peut-être une remarque un peu finale alors, pour ce qui me concerne sur le rapport entre les formes de juridicité traditionnelles et ces nouvelles formes de juridicité qui sont pas vraiment nouvelles. En fait, bon, il y a une parenthèse historique qui correspond à la montée de l'État, mais qu'on pense à l'Europe médiévale pré-westphalienne, et on est dans un enchevêtrement. Le pluralisme juridique est la condition chronique de la plupart des sociétés. On le redécouvre maintenant parce qu'on a été tellement obnubilé par le monisme étatique qu'on l'a un petit peu oublié. Mais I was thinking, especially in conditions of globalization, one of the cliches is sort of the waning of the state, and it's true of the incredible power of a number of private actors. It simply is no longer sufficient to say the state is responsible for everything, because the state's reach is limited, and that is not the same thing as saying the state has no role to play. Corporations, strategies that aim to have certain corporations who violate human rights abroad prosecuted in certain countries should be pursued. But I'm thinking particularly of the Ruggie principles and this whole idea that corporations need to discipline themselves, which is still in its infancy, and which I sometimes hear criticized by some colleagues as traditional international human rights law colleagues who wouldn't even teach it in their courses. Well, that's not international human rights law because there's no sanction. And so this fixation on the idea, well, if there isn't a court system and a case law, then it's not law. When in fact we know that these corporate codes of conduct have limitations, but and they're problematic. But they are part of the evolving normative reality of human rights, and I think human rights lawyers ignore them at their peril.
Okay, well that's, I think, perhaps a good place to close the formal part of this dialogue. And so I just wanted to take a moment on behalf of everyone to thank my colleagues for sharing their insights and their personal intellectual trajectories with us, and and for making this, I think, initial conversation so interesting. So thank you very much. Okay, so that's the formal end. I know there may be questions from the audience that we have a few minutes, actually very few minutes, but if there's any burning questions, or you can ask after the formal session. Anything anyone wants to jump in that you've been keen to ask? Fred looks like he's ready to go.
I'll just jump in with a very short remark, because I think that legal pluralism is indeed frightening in that sometimes it makes you think of this, what you referred to, René, as this flou. But anybody who was at the talk, was it yesterday or 2 days ago, by Jacques Frémont, will remember that he spoke about the heydays, the first 40 years of the Charter, and you could say the very same thing about the Canadian Charter. We talk about the heyday, and the wonderful days, the golden age, and how we feel that there's a certain maybe conservatism that's settling in, etc. And that can also be very demotivating and demoralizing. What I thought was inspirational today, and I thank you very much for a very, very, very exciting debate. I found it extremely, extremely interesting. And what I think that it does allow us to do is so much think outside the box then. It's not the end of the debate. It's not the end of the story. There's still, I think, from this, suggestion of legal pluralism, so much else to do, but at other levels. And they're not exclusionary. They're not incompatible. We always have to remember that. But I thought it was actually very encouraging in many ways. Thanks very much.
Okay. Thank you for that comment. Yes, Eloge?
Eloge, former student of yours. I found interesting you touched on the moralizing or morality of human rights. But most people in the world who are not lawyers, who don't necessarily understand what their rights are, believe that there's such a thing as the rights that are inherent to them by virtue of being human beings. And it's increasingly a compelling claim, especially in relations between states and peoples around the world. And I wonder how that moral dimensions shape the way you present and think of your work in a faculty where a chunk of the Universal Declaration was written, whether you feel that pressure that you're working towards a certain unidirectional goal.
Let's jump in there.
It's a good question. I mean, so, there's this, classic Weberian dichotomy, le savant et le politique. I mean, do you, if I understand correctly your question, maybe that's one way of thinking of it. I mean, does studying and working on human rights mean that one is doing human rights and sort of actively involved in the ideological, moral, philosophical project of human rights? Is a good question, one that I often ask myself. I mean, I think there's sometimes an expectations in my class that I'm a kind of indoctrinator en chef. It's going to be praising the virtues of human rights, and I sense after a few weeks sort of students' disappointments, as occasionally as I introduce layer and layer after layer of skepticism. I mean, at the same time, I do realize that it was a sort of great privilege to be, have a chance to work with these intellectual categories, and there is something which is intuitively appealing, and beyond all of it, I think interesting ethical questions about what it means to teach human rights, what it means to teach human rights law. To what extent the two overlap? How does one manage expectations about what can be achievable whilst encouraging, radical thoughts about what can be achieved at the same time? And I think John Humphrey, highly esteemed former colleague who was one of the drafters of the Universal Declaration, was an interesting synthesis of the various roles that one can take over a lifetime within that sort of broad community. He was a UN bureaucrat, he was a lawyer, he was a professor, and he, I think, navigated these different roles in ways that, I think, betrayed ultimately a very strong commitment to the values of human rights, and probably a stronger commitment to the idea of international human rights law than perhaps I would share. But certainly it's certainly interesting to think of ourselves as part also of this larger tradition which emerges at McGill in Quebec and is also close to a local history. and not just a universal history.
Yeah, I would just add that one way to think about your question is to evoke Paul Kahn's book on the cultural study of law, where his central point really was that lawyers shouldn't necessarily only be working in law to try to discover what the right answer according to law is, but also should be working on law, to look at law as a social phenomenon, to ask what does it say about us as humans, about us as a community. Where I diverge a little bit with Kahn is that he presents those as quite distinct endeavors. I think that we're always doing both, necessarily so. And I think the examples of individuals working in human rights law can indeed capture this necessary diversity. I mean, we can add another Earthswide colleague. No, I was actually thinking of another one, Erwin Kotler, who was a teacher, a researcher, a politician, an activist, all at the same time. And so I think it is not a stark choice that we must make, but rather merely a realization that we cannot invest ourselves necessarily quite fully in each one of those dimensions at every moment, and that we might have, an ebb and flow of emphasis on different categories.
There's also one way in which I think a legal pluralist lens highlights the agency of the individual in making law, not just in receiving or interpreting law. And I always think of Martha Minow's work on children's rights in schools. Should children have rights in schools, or does that make sense from a children's rights perspective? But she emphasizes rights claims as part of a dialogue, where the child, in asserting that claim, is engaged in articulating a vision of what rights are or what law is, which may not be or may be recognized by the formal legal system, but that we, even at the institutional or everyday level, have agency and are engaged in participating in the morality and the making of norms that constitute a broader conception of our human rights legal order. So
my daughter likes to say, mais j'ai droit au bonbon.
Wait, the right to potato chips, that's what I... Okay, well, on that note, I think we'll thank you all for attending, and thank you again to our conversants, and I think this was a wonderful session. So.
Thank you.